The problem, for years, if you were a sick or injured airman, the Air Force was supposed to run you through a process that decides your military disability retirement and your VA disability rating before you ever leave the service. Congress designed that process specifically so no service member falls through the cracks. But a federal court just ruled that thousands of airmen were illegally kept out of it, sometimes with a documented serious medical condition and a doctor already recommending further evaluation. The solution, what this ruling actually says, who it affects, and the 4 things you should do right now, whether the court has ordered a fix yet or not. I am A. Perkins, former U.S. Air Force nuclear missile launch officer and disabled veteran. I am the author of 6 Amazon best-selling books, all 6 ranked in the top 100 of their categories, and my 2 VA books ranked in the top 10, and I am the creator of the Avoy Veteran Navigator. The guidance I am about to give you is proven. Let's go. On August 10, 2026, the U.S. District Court for the Eastern District of Virginia ruled that the Air Force built its own unauthorized pre-screening process that quietly diverted thousands of sick and injured airmen away from IDES, the Integrated Disability Evaluation System. IDES is a Joint Department of Defense and VA program. Congress designed it so a service member with a qualifying medical condition gets referred to a medical evaluation board, receives a VA compensation and pension exam while still in uniform, and can leave the service already knowing their VA disability rating, often within about 30 days of separation. The court found the Air Force's pre-screening violated the Administrative Procedure Act and was arbitrary, capricious, and contrary to law. According to the National Veterans Legal Services Program, which represented the plaintiffs in this class action lawsuit, court documents show Air Force members were denied IDES access from at least 2019 to the present. Here's what that looked like for a real person. One named plaintiff in the case, a certified physician's assistant who served 12 years, was diagnosed with a blood clotting brain condition. Her own neurologist said it put her at risk of permanent blindness. Under the process Congress designed, that diagnosis should have triggered a medical evaluation board automatically. Instead, she was returned to duty and discharged in 2023. No medical board, no continuity of care plan, according to court filings. If you left the Air Force any time since 2019 without ever being referred to a medical evaluation board despite a documented medical condition, this ruling is about you. Here's why this matters to your wallet, not just your medical file. When IDES works the way it's supposed to, you leave the Air Force already knowing your VA disability rating, and that rating decides what happens next. A combined rating of 30% or higher at separation means medical retirement, monthly disability pay for life, plus other benefits tied to retiree status. A rating of 20% or below means a one-time severance payment instead, with no guaranteed path back to VA compensation later. You'd have to file a brand new claim after separation and rebuild your evidence file from scratch on your own without the C&P exam the military would have already scheduled for you. The Air Force's pre-screening skipped that entire pipeline for an unknown number of airmen. Instead of a medical board and a VA-administered exam, they were simply returned to duty, sometimes with a documented serious medical condition and a doctor on record recommending further evaluation. The class has been certified, but the court has not yet ordered a remedy. It's still deciding what the Air Force owes affected service members. That's not a reason to sit and wait. A class action remedy can take years to actually pay out, and your own VA effective date is protected the day you file, not the day the court rules. Here's the organize before you file approach, step by step. Step 1, check if you fit the pattern. Air Force active duty or veteran diagnosed with a condition affecting your ability to perform your duties anytime from 2019 to now and returned to duty instead of referred to a medical evaluation board. Example, you separated from the Air Force in 2021. During your last 2 years of service, a flight surgeon documented a shoulder injury as limiting your duties, but no medical board was ever convened. That gap, a documented condition with no IDES referral, is exactly the pattern this ruling addresses. Step 2. Pull your records now. Medical records showing the diagnosis, any provider note recommending a medical board or further evaluation, and your separation paperwork showing no IDES referral occurred. Example, request your full service treatment record and your DD-214 packet. Look specifically for any line in a provider's note that says something like, refer for MEB evaluation, or unfit for full duty. That's the paper trail that proves the referral should have happened. Step 3, file an intent to file today. If you haven't filed a VA disability claim yet, don't wait on the lawsuit. An intent to file locks in your effective date and protects your back pay while you build your case. Example, if you submit an intent to file this month but don't finish gathering your full evidence file for 6 months, your effective date is still this month, not 6 months from now. That's real money you don't lose to paperwork delays. Step 4, build the nexus yourself. A missed IDES referral doesn't file your claim for you. You still need medical evidence connecting your condition to your service. The same evidence VA would have gathered at the C&P exam you never got. Example, if your IDES referral was skipped, you may need to request your own compensation and pension exam through a standard VA claim or get an independent medical opinion connecting your current diagnosis back to the in-service treatment notes you pulled in Step 2. A few questions come up every time I cover this. Am I automatically part of the class action? The class covers current and former Air Force members, but whether your specific situation qualifies depends on the facts of your case. This video is educational, not a legal determination, so talk to NVLSP or a VA accredited representative about your situation specifically. Does this change your current VA rating if you already have one? No, this ruling does not lower any existing rating. It addresses veterans who were denied the chance to be evaluated in the first place. And if you already separated and filed a VA claim afterward without ever getting an IDES referral, does this help you? It may support an argument that your rating or effective date should have started earlier, since a documented condition should have triggered a medical board before you separated. Build your evidence file now and walk through the timeline with a VA-accredited Veteran Service Officer. This is exactly the kind of situation the AVOI method was built for. When the system fails to do its job on schedule, the veteran who has already gathered their own evidence is the one who gets paid faster, not the one who waits for someone else to fix a broken process. This entire organize before you file method is what my books lay out step by step, including common VA claim mistakes, which covers exactly the kind of gap this ruling exposes. Go to avoivet.com and ask the Avoy Navigator whether this ruling affects your claim. Hit the subscribe and like button. When you subscribe, you get a free copy of my book, VA Disability Claims for Beginners. Just check the description to claim it. I am A. Perkins. Educational only, I do not file or represent claims, and I am not the VA. A federal court just ruled in your favor. Now make sure your file is ready. Got your 6.